All right, just a moment. I'm going to call the docket. When I do, please say present or here so I can acknowledge you for the docket. Also, before we begin, I'm sure that you are aware of the current rise in COVID cases, so I'm going to encourage you to wear a mask and maintain social distancing as much as possible. You're free to spread out in the courtroom. Be mindful when you're in the common areas of the courthouse, bathrooms, hallway, restroom, elevators. Keep as much space between yourself and others for your own protection and that of others. Blake Ekrit. It's Blake Ekrit here. Stephen Foster. See, I have a note that he's been verified in the Hunt County Jail. We'll recall him later. Richard Blevins. Richard Blevins. Paul Cohey. Melody Dollar. Was this one of the cases that we reset so that she could enter that Genesis Center, or did she just enter it before her plea?
She just entered.
Was she supposed to plead today?
We were set to get her.
Does she have any way to get here today?
I notified Ms. Abraham and the state, and I'm trying to contact the W. Robbins Genesis Center and see if they have arrangements instead of a Zoom.
Okay, well, she's set for pretrial otherwise, correct? If she's not going to enter a plea today, she's set for pretrial.
That's right.
So if she can appear via Zoom, obviously she's not gonna be able to plea because she can't sign the paperwork or get fingerprinted.
I'll see what arrangements.
Okay. Yeah, find out what she can do. I'd like to have an appearance by her one way or the other. David Jones. Thank you, ma'am. Cameron Luce.
President of Council.
Thank you, Mr. Falls. Logan Bundrick.
Here.
Misty Backus. Calixta Rosa. Calixta Rosa. Mr. Manning, you know anything about Mr. Rosa?
Yes, Judge. I met with Mr. Wood, so last week, went over the discovery sheet and offer. He is one that he's going to accept at this time. He's about on time for his usual appearance. So I'll step out after the docket and see if I can contact him.
Okay. What's he pleading to?
The judge should lead to possession of dangerous drug. And there's two forward violations.
Time or probation?
Probation.
So you know that probation requires a schedule?
We discussed that.
Maybe a problem for him. Randy Dobbins. Randy Lee Dobbins. Jason Nichols. Mr. Nichols, come on forward. I'm gonna have you drug tested before I call your case. Justin Cook,
Your Honor, I believe it's bond filed after they go off bond. I don't believe
I don't know if I've seen that. I see a note about a pardon and parole warrant. Maybe
there's one of those.
one of those two. Okay. Thank you, Mr. White. Roy Hamilton. Justin Wright. Jaime Sarate. Thank you, sir. Brittany Hamilton. Brittany Marlene Hamilton. Jason Hodebeck, verified Rains County Jail. We'll recall his case for scheduling. Charles Howard. Charles Justin Howard. 0 for 3, Mr. Schmidt. 0 for 3. And this is after the All-Star break. Christopher Mata. Douglas Mercer. Chad Osterreich. Derek Piscotta. Justin Reed. Mark Vargas. Mario Gutierrez. David McLaren. Raul Lopez. Mr. Lopez may be appearing via Zoom today. Let's see. And Mr. Lopez is in the waiting room with Mr. Abrams. Myra Garcia Escobedo. Thank you, sir. Ms. Kofer is not set till 11. Is Rochelle Kofer here? Yeah, she's set at 11. Is there anyone who's present in the courtroom whose name I have not called? Page 5. Page 5. Page 2, number 5. Mr. Dobbins, it's nice of you to join us. Anyone else in the courtroom whose name I've not called? All right, counsel, we have anyone that's ready? If y'all line up over here, if y'all line up right over here, Mr. Files, I'll take you first. Mr. Luce, you'll come on up to this center podium. We're going to do things a little different today. Try it out. My docket's not quite in order. Let's see. This is CR 21-130, State versus Cameron Luce for docket call. Go ahead, Mr. Fowles.
Hey, please, Gordon, this current representing this about this case, we do not yet have an office in the state. With the virtual survey that's going to be worked out. He has companion cases in Wood County, they're set for this week. We should be ready by the next call, at least a month away, to resolve these cases.
So no offer's been made to the defendant?
And so, as of this point, we consider with, did not show anything. As I say, we're continuing to negotiate.
Does the state show anything in their file as to an offer? While he's looking, are you available on September 14th? If your client's on bail, it'll be at 9 a.m. If he's in jail, it'll be at 1:30. If he's on bail at 9 a.m. in jail, 1:30. All right, court will set Mr. Luce for docket call on September 14th.
My client is whispered in my ear, and he is a docket call in Denton County, I was unaware of on September 14th.
September 16th.
September 16th. Clear on that. We would be ready on that.
Judge, I don't see any notes about any operations in the file that's not in the it's not formulating one.
All right, Mr. Luce, the court's going to set you for docket call on September 16th at 9 a.m. Once you sign the notice, you're free to go.
That's all the mission. I might have a-
Yes, sir. Thank you, Mr. Falls. Who's next in line over there? All right, Mr. Cohey is to enter a plea today. Is that correct?
That's correct.
Mr. Cohey, if you'll raise your right hand. Mr. Cohey, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? All right, you may put your hand down. Your name is Paul Robert Cohey, is that correct? And Mr. Cohey, I see that you are charged by indictment with a third-degree felony offense of assault of a family or household member by impeding breath or circulation. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years and a fine not to exceed $10,000. Do you understand that? Have you ever, are you a United States citizen? You read, write, and speak English? Have you ever been diagnosed with any type of mental condition? What have you been diagnosed with? Are you currently on any type of medication for those? Do you feel like those medications are assisting you today and giving you rational understanding of the proceedings? In this case, you're represented by your attorney, Mr. Gimbel. Are you pleased with his representation of you? Feel like you've had enough time to discuss the case with him and have all your questions answered? Is there anything about this paperwork that you've read and signed that you do not understand? Mr. Gimbel, do you believe Mr. Cohey to be competent today? You've explained to him his legal and constitutional rights. And you've also gone over the conditions of community supervision with him.
Yes, I have, Your Honor.
All right, Mr. Cohe, I see the proposed plea agreement is that you plead guilty to that charge in exchange for the state's recommendation that your sentence be assessed at 10 years confinement in TDC, with that being suspended and you being placed on probation for 5 years. You would also have a $5,000 fine, court costs, reimbursement fees. Is that your understanding of the plea? And that's what you want the court to approve today? How do you plead to the third-degree felony offense of assault of a family or household member by impeding breath or circulation? Are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty today? All right, court accepts the defendant's plea of guilt at this time. Mr. Gimbel, any objection to states one?
Okay.
All right, states one is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state, from the defense? All right, the court's going to follow the plea agreement in this case. Court does find that there's sufficient evidence to convict Mr. Cohe of this offense. The court convicts Mr. Cohe of this offense, assesses his punishment pursuant to the plea agreement at 10 years confinement in the Texas Department of Criminal Justice. Court suspends that sentence, places Mr. Cohe on community supervision for 5 years, orders him to pay a $5,000 fine, $290 court costs, and $785 reimbursement fees. Mr. Cohe, have you been on probation before? You haven't? You understand how probation works, correct? You understand that if you violate any of the terms of your community supervision, you could be brought back before the court. And if proven to the court that you violated, court could revoke your community supervision and assess the punishment of 10 years. You understand that? So the agreement is from the state that they give you probation, and your agreement is if you violate and are brought back on a motion for a hearing, that if the state proves their case, then your agreement is that you'll go to prison for 10 years. You understand that? All right, Mr. Cohe, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'll have you step forward here with the deputy so that you can be fingerprinted.
Dollar, I will contact the Justice Center and see what arrangements to be made. Regarding her
Thank you. I appreciate that. Just,
business excuse.
yeah, well, are you going to report back to me on what you find out from the Genesis Center?
I'll know from the state. When I get back in the office, I have another hearing in the county.
Okay.
To attend to today, but when I return to my office, I will contact
Okay.
the Justice Center and I will. State.
All right, thank you. You know, otherwise, if I don't hear back, or we don't have any update, I'll have to issue a warrant for arrest.
The state is providing me with, sleep for her probation, and the probation department provided me the terms and conditions, all things, just need to see.
Okay. Yep, you may be excused. Thank you, Mr. Gimbel. Ms. Broom? Mr. Jones? Do we have any interpretation on this one? Okay, who's that on? I can see it on. The last one. One instead of 9:30, so. Sure. Just want to make sure that I didn't miss it. I turned that game on. All right, thanks. All right, this is CR 21-128, State versus David Ray Jones. Mr. Jones, show is set for a docket call and possibly a plea today. Is that correct?
That is correct.
All right, let me see here. So the proposal is Mr. Jones pleads guilty to the indicted charge, 3rd-degree assault family household member by impeding breath or circulation. State's recommendation, finding of guilt be deferred, and Mr. Jones be placed on 5 years community supervision with fine, court costs, and reimbursement fees. Is that correct?
That is correct.
All right, Mr. Jones, if you'll raise your right hand. Mr. Jones, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. All right, Mr. Jones, you are David Ray Jones II, is that correct? And Mr. Jones, are you a United States citizen? Do you read, write, speak English? Ever diagnosed with any type of mental condition? All right, are you currently on medication for those? Do you feel like you have a rational understanding of the proceedings today? Understand what's going on in this case? In this case, you're represented by Ms. Donna Broom, your attorney. Are you pleased with her representation of you? Feel like you've had enough time to discuss the case with her and have all your questions answered? Anything about the paperwork that you've read and signed that you do not understand? And you've gone over all the conditions of community supervision. Ms. Broom, do you believe your client to be competent today?
I do, Your Honor. I've spent considerable amount of time with the and discovery with the it's competent.
Thank you. Mr. Jones, being indicted as a 3rd-degree felony offense of assault of family or household member by impeding breath or circulation does carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. If I accept this plea agreement today and later I find that you have violated your community supervision, the court could revoke your community supervision, adjudicate your guilt, convict you of that offense, and assess your punishment up to 10 years, anywhere from 2 years up to 10 years with a $10,000 fine. You understand that full range of punishment? Understanding the plea agreement and the range of punishment, you want the court to approve this today, is that correct? How do you plead? And are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty? All right, court accepts the defendant's plea of guilt. Ms. Broom, any objection to states 1, the stipulation of evidence?
No objection, Your Honor.
All right, states 1 is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. In respect to the guilty in this case, as there is an affidavit of non-prosecution on file, state is compliant, however, we received no response to the farming subsequent.
Thank you, so. Anything further from the defense?
No, Your Honor.
All right, based on the court's review of the evidence, I do find there is sufficient evidence to convict Mr. Jones of this offense. However, the court will follow the recommendation of the state. Court defers a finding of guilt, places Mr. Jones rather on deferred community supervision for a period of 5 years, orders him to pay a $2,500 fine and $290 court cost. In addition, the court orders a reimbursement fee of $35. All right, Mr. Jones, you hereby remanded to the custody of the Community Supervision Department so they can carry out the terms and conditions of the order. I'm gonna have you step forward to be fingerprinted with the deputy, and then after that time, step over here to Officer Mature and you'll get additional instructions. All right. Thank you, Mr. Brown. Yes, ma'am. Thank you. Mr. White, are you ready? Logan Dwayne Bundrick, CR 16630, CR 18391.
None of this is a motion to also make events. They were not related actually, but I just received the EDD on the daily arrest charge today. Like I said, while they're not directly related, I feel certain we can solve things at the same time, so I would be asking for some time for me to get them to get here. Say that's in the opposition. I did file pre-trial motions. I did notice though this morning that on the motion for discovery order, I have the wrong heading. I have refiled it, but I also have an original hard copy of the court record.
No, that's fine. E-file copy would be fine.
Okay.
Do we need to take up those pre-trial motions at this time?
There.
Okay, I'll get this. All right. Do you have your calendar available?
Yes, I do.
Do you believe September 14th or 16th would be?
14th, I'm already here. I believe.
Well, let's do that then. All right, Mr. Bundrick, I'm going to set you on both cases for September 14th at 9 a.m. And we'll reset pretrial in the evading case.
Was 14th.
Yes, September 14th. All right, Mr. Bundrick, you're free to go. Mr. White. Mr. White, if you'll approach.
Good morning, Your Honor.
Good morning, ma'am. How are you?
I'm doing very well. Good to see you.
Great to see you as well. Let me make sure I've got everything set up on my end. It looks like I do. Let me make sure I've got you added. Does everything appear to be functional on your side?
It seems and has the court access the language channels, Your Honor?
Yes, I'm on the English channel in this
I
table.
don't,
Are you on the Spanish channel?
Your Honor, I have not received the invitation. In other words, you need to access me as interpreter. If you go back to your meeting, just the way you do it with Leo, with Leonard, you need to write down my name. You need at the box where it says in, I believe it reads interpreter. Rather than having the interpreter's email address, you need to go back, erase that, and write down my name, Maria de Villas, the way it's shown on the screen.
Yeah, we're gonna need a moment for doing that.
Mhm.
Just 1 second. Yeah,
Of course.
I can't do. What about now?
Hi, I'm looking at it. Thank you, Your Honor. I'm okaying it, and I'll be choosing the Spanish channel. And I'm assuming at the podium, you'll do the same. Thank you.
Is her volume up on her headphones? Yes, you should. Please go ahead. She can't hear you. Okay, thank you. All right. And so, ma'am, if you'll raise your right hand, I'm going to place you under oath as the court's interpreter. Do you solemnly swear that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? Thank you, ma'am. All right, the court has called cause number CR 21-167, the state versus Myra Garcia Escobedo, and we are set for pretrial day today. Mr. McCaslett, any contested pretrial motions on file?
None, Your Honor. We're continuing our negotiation. I believe it's going to be resolved.
Okay, so
There are no pretrial issues at this point. We're continuing our negotiation. It's our hope to resolve it by our next past date.
Ms. Villiers, any better? Let's try one more time. We'll see if you can say it a third time exactly like the first two times.
Mrs. Drucker, can you hear me now? Your Honor, we're asking for a reset to September 16 to continue our negotiations to resolve this matter. We received discovery on the case. I don't believe the pretrial motion in the future. I think we could get it resolved by the 16th.
Okay, so there are no contested pretrial motions, no motions to quash or motions to suppress.
That is correct, Your Honor.
Okay, all right. Court finds that since there are no contested evidentiary motions, court will set this for a docket call on September 16th. That was the requested date, correct, Mr. McCaslett?
That is correct, Your Honor.
Okay, September 16th at 9 a.m. Ms. Garcia, once you sign the course notice of setting and get the yellow copy, you are free to go. And Ms. Interpreter, if you'll ask the defendant if she has any questions of the court or if she understands today's announcement.
No.
All right, then we'll be adjourned in this case and we'll see her back on September 16th.
Now, this matter.
You may be excused on this matter. Yes, sir. Yes, ma'am. Thank you very much. Been a pleasure as well. Thank you. Ms. Tabraham. I see no other counsel in the courtroom, so guess we'll wait. All right, this is CR 20-264 State versus Douglas Mercer. Show that we're set today on a status for the urinalysis confirmation in our previous setting. I'm not sure if we're set for anything else.
I think that we were, last time we were in. Now straight. I think it's supposed to carry on. Not sure. Got it set up.
All right, it's Mr. Waddell, or who has the knowledge on the confirmation that we sent off on Mr. Mercer? Come on over here and I'll swear you in. If you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Officer Waddell, do you have any additional information for the court on Mr. Mercer's drug test confirmation from the urinalysis that was taken in the previous setting?
Yes. The results came back negative for eating those substances. It was. My question was, is it taking the same as at that time as it was? Which was issue of down on prior tests.
And have you had any discussions with Mr. Mercer today to?
Not yet.
Okay, so any questions of Officer Waddell at this time, Mr. Schmidt?
I was a little unclear, but we had a false positive environment. We said this one out for combination. So. It's not tested.
My question would be, is it still taking the same as a month ago?
And yes, it's not. What we're justifying here and what we're justifying to the last time.
The lab technician stands on this position. Genuine positive.
On the in-court viewing,
Yes, sir.
but the lab confirmation says that it's a negative.
2 months ago, the lab showed that he was positive for meth. And we discussed that it was a potential false positive. So I tested him last court day to verify if that medication is our tests were true. Still taking the medicine, it did not show any kind of indication of meth last month.
Okay, so I think I follow. So you've UA'd him twice, and one time he came back positive. We sent it off. It's a negative, and you've UA'd him again, and the UA was negative.
Yes,
So if he's taking the same kind of medication, we should get the same result each time.
yes,
So if I test him right now, it should come back positive for meth.
yes.
All right, well, Mr. Mercer, go with Mr. or Officer Waddell, give another test, and we'll recall your case in just a minute, okay? And have you, Mr. Schmidt, you've given that prescription medication to the probation department, correct?
I have not. We discussed it. We discussed it. I do know. Last time with this Russian last time, he was tested. Said, that's when after the period on whether or not it's false positive. And then the problem is what else? Sending out the combination. I'm not aware of the prior.
Yeah, well, I'll call your cases real quick, get through these, and I'll let you go talk with him. I can't recall that specifically either. Chad Osterreich. This is CR 2222, except for pretrial?
Excuse me, Judge. Though the court know that there are some companion cases during last one. The all the transactions alleged to occur in this case in Van Zandt County actually took place in Cass County. And so in the process of serving some search warrants in Cass County, those officials seized a lot of evidence, on games, videos, etc. We received the discovery that this DA's office has. I know from talking to my clients, lawyers, understanding the case of Cass County, that there is some quite a bit in their file. So I've asked through Hillary, Ms. Curry, to see if she can specifically get their hands on the body. There were quite a few offices all. So we know they exist. And so because of that lack of discovery with us, I discussed that with Ms. Hyde.
And Your Honor, obviously, we're not opposed to a reset to resolve those issues. Ms. Curry has the contact information for the investigators in other jurisdiction. So I forwarded on to request her. Hopefully get those before the next 7 years.
And so explain to me again the relationship to Cass County.
So Judge, basically, the allegations are that we have a midway volunteer fire department. We have multiple fire departments in various different counties. We're doing business with family members, Michael. And so all of them had similar complaints at the same time. So the candidate got time with state fire. And anyway, they did this search warrant at their place of business, not William's place of business, but his son's place of business, which is in Cass County. So all that evidence of anything that may be pertaining to this case is seized in Cass County. And so the discovery I have has various photographs taken from that location in Cass County. All of the transactions took place in Cass County. The only thing connecting those incidents, in my understanding, to Van Zandt County, is a contract between the fire department. And so when they did that search warrant, they seized evidence to the pictures. All of those photos we have, but there are quite a few videos that we have. First of all, but we know they exist. So I don't think that the officers submitted any of that to Van Zandt County. I doubt Ms. Curry is aware that they exist, but we are aware that they do. So that's what we do.
Think it'll take more than 30 days to get your hands on those things?
Probably. Because I think that if, I think it'll be a struggle to start simply because of lots of issues in Cass County as well. Some coordination between myself and
October 12th or 14th. All right, Mr. Osterreich, court sets you for pretrial on October 12th at 9 a.m. Once you sign the notice of setting, you're free to go. Justin Reed. Still working on paperwork. Okay. Mr. Reed. Mr. Reed, you raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. This is cause number CR 2406.
Information proceeding on the lesser included state jail proceeding in the full court.
All right, Mr. Reed, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to discuss the case with him, have all your questions answered? Is there anything about the paperwork today that you've read that you do not understand? Mr. Schmidt, do you believe Mr. Reed to be competent today? All right, Mr. Reed, you are charged by indictment with a felony offense of possession of controlled substance in penalty group 2 less than 1 gram. However, the proposed plea agreement is that you're going to plead guilty to that offense under section 1244B, which would mean that you would be convicted as a misdemeanor offender with a misdemeanor punishment with recommendation at 1 day in the county jail with credit for time served. You'd be obligated to pay court costs and reimbursement fees. Is that your understanding of the plea agreement? And that's what you want the court to approve today? The range of punishment for a Class A misdemeanor is confinement in the county jail for a period not to exceed 365 days or a fine more than $4,000. You understand that? So understanding the range of punishment and the plea agreement in this case, how do you plead to possession of controlled substance, penalty group 2 less than 1 gram? You're pleading guilty because you are guilty of committing that offense. Has anyone threatened, forced, or pressured you to plead guilty? Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to states 1? States 1 is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, I will note that the court, in creating this plea deal, we would consideration of fact, Mr. Reed is previously pled to the legal marijuana. He actually pled to that before we received the results on the felony case. Had we received those before, we probably would have resolved back into that. That's why we're not asking for fines. Served some time and by itself, we likely would not have done had we known. That is the reason why it's potentially less than what it would be, because he's already resolved his business point throughout the process. We would ask that the court follow the clear.
Thank you, Mr. White. Anything further from the defense? All right, based on the court's review of the evidence, I find enough evidence to convict Mr. Reed. The court will follow the plea agreement. Court convicts Mr. Justin Blake Reed of possession of a controlled substance, penalty group 2 less than 1 gram under section 1244B, Class A misdemeanor. Court assesses his punishment at 1 day confinement in the county jail and gives him credit for 1 day of time already served. Court orders him to pay court costs of $270 and reimbursement fees of $35. Is Mr. Reed discharging his court costs and reimbursement fee today? Thank you, Mr. Reed. All right, Mr. Reed, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. And have you step forward to be fingerprinted by the deputy. After that, you can get a copy of this and you step across the hall to the clerk's office and they take your money there. Mark Vargas. All right, CR 29-4, State versus Mark Henry Vargas, docket call.
Is, who has the rendition, call and seek from the state? My time to discuss and explain it for artists as well.
September 14th or 16th. All right, Mr. Vargas, I'm going to set you for an additional docket call September 14th at 9 a.m. Once you sign the notice of setting and get your copy, you're free to go. Do you know if Brittany Hamilton appeared? Oh,
Hampton Hall,
Hamilton and who?
Howard.
Howard. Brittany Hamilton, CR 2170. CR 2170, State versus Brittany Marlene Hamilton, set for pretrial.
That's correct, Jules. We received your recently. That's what we on Smith County as well as Howard and equipment. So I get them both.
All right, court sets Ms. Hamilton for an additional pretrial on September 14th, 9 a.m. Ms. Hamilton, why were you late this morning? Why were you late this morning?
Because our the.
We'll see you back on September 14th. Mr. Howard, CR 2176. Court accepts the statement from Mr. Schmidt regarding Mr. Howard. Court sets Mr. Howard for pretrial on September 14th, 9 a.m. Mr. Howard, once you sign your notice of setting, then I want you to step over here to pretrial release, and I want you to make a payment today. I show you're $180 delinquent. 180 delinquent. Get your stuff and go see probation department. Yeah, talk to them about it. They'll work with you. What about Christopher Mata? Did he show up? Christopher Mata? Quarterback? Scotland? Yeah, let me call it real quick. CR 2130, State versus Derek Phillip Escada, set for docket call. Go ahead.
Communication with this Yoda's employer, they're in Nebraska. asked him to get doctor's note or something. Basically, so they travel together. So they have a copy of the code. But that's why he's not here. If we
So they had a positive in their work group.
Yes, sir. This was 3 men into a hotel room. And the doctor is sick. The rest of the based on the case.
What's the announcement on docket call?
Judge, I think that state last time we were here made a curiosity, we're likely, most likely the next time. Set that off.
Do you think your client could check in via Zoom at some later point?
Sure you could.
Okay. All right, we'll reset docket calls to September 14th. I'll take the NISI under advisement until noon on Thursday. And he'll need to check in with Ms. Taberham. And she can, if he'll call her, she can give him the Zoom information, and if he'll check in via Zoom with her.
Yes, sir. This morning,
What about Mr. Hodebeck? I show he's in Rains County. Let me call that one. CR 2121 and 172 State versus Jason Adam Hodebeck. Do have verification that he is incarcerated in Rains County Jail. Do you have any information on that? Do you know why? You're not aware if Mr. Nicholas has gone off his bond at all, do you? Or done a surrender? All right, I'm gonna reset both of those for September 14th. And we'll do a status, we'll do docket call on one pretrial. Can you make a pretrial announcement on the possession case 172? Do you have any contested? Okay, what we'll do is we'll set both for docket call on September 14th, and we'll do a status on custody. You'll check on Mr. Mercer and let me know. Council, who's ready? Is it Rosa? Mr. Rosa? Is this CR 21 case a newly indicted case, or was it transferred? I
It
don't
was
know.
filed by information, I believe, last week.
I just don't have it on my docket.
Judge, they were waiting for a lab report back, and once we came to an agreement, this was the best course of action. So they were waiting to file it based on that. issue, waive will have to go forward.
Is there a lab waiver form in here? But if not, then you'll need to, I want you to take your client.
Absolutely.
All right, Mr. Rosa, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Your name is Calixto Rosa, is that correct? And Mr. Rosa, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you? You feel like you've had enough time to discuss your case with him and have all your questions answered? Anything about the paperwork that you've signed today that you do not understand? In CR 21-273, you are charged by information with a Class A misdemeanor offense of possession of a dangerous drug. I see that the plea agreement in that case is that you would be pleading guilty for the state's recommendation of 7 days confinement in the county jail, with you receiving credit for all 7 days of time served, that you would be ordered to pay a $1,500 fine, and the state would be dismissing 2 other cases, a tampering and a DWI. In addition to that, you would be ordered to pay a reimbursement fee of $915 to the county, $270 court costs. Is that your understanding of the plea agreement? Mr. Manning, is your client going to be paying any of this to the county today?
No, he's not judged, but he is when he said our payment plan, based on his indigency status, that the court found previously. He is doing his best to make his court costs and pretrial release fees. He's going to continue doing that, full in the work with Ms. Pauline Pratt, and then giving him the card for her.
All right, Mr. Rosa, the range of punishment for a Class A misdemeanor offense is confinement in the county jail for not more than 365 days and a fine not more than $4,000. Understanding the range of punishment in the plea agreement, how do you plead to possession of a dangerous drug, Class A misdemeanor? Are you pleading guilty because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? All right, court accepts the defendant's plea of guilt. Any objection to states one?
Okay.
States one's admitted into evidence and court takes judicial notice of the defendant's judicial confession. Anything further from the state? Mr. Manning, I want you to discuss with your client, have him testify to me about waiving the lab in this case.
You were charged with 3 different cases, is that correct? And one of the things we discussed in our all the discovery we've been given last week was that there was no labs in any of the cases, in the tampering case, the possession case, or in the is that correct? And we talked about the pros and cons of that. We talked about how the state has to do their work, the way they do that is they provide a lab. But you received an offer that you were willing to take responsibility for being possession of the evidence. Is that correct? And you admit that you were in possession of that evidence. You don't need a lab from the state in order to prove that. Is that correct? And you understand that if a lab would come back after you and it came back and said it wasn't evidence, you wouldn't have to be forced to undo this piece of the way the field can undo this. Is that correct?
Any questions?
No, Your Honor.
All right, the court will follow the plea agreement in this case. Court hereby convicts Mr. Rosa of possession of a dangerous drug, Class A misdemeanor, assesses his punishment at 7 days confinement in the county jail, gives him credit for 7 days served. Court court orders him to pay a $1,500 fine, $915 reimbursement fee, $270 court cost. Court takes into consideration CR 2409, DA 2020-866. Mr. Rosa, the bailiff's going to hand you a card that has the contact information for the court collection officer. She's out today, but I want you to give her a call next week sometime so that you can make arrangements to pay your fine or pay your fine, court costs, and reimbursement fees. Failure to do that is going to result in the court issuing a warrant for your arrest. Do you understand? Okay. All right. I'll have you step forward here with the deputy, be fingerprinted, and then you'll be free to go. Do you have a motion to pay on that one? Or are you doing, you're going to send it, you file?
Yes, Judge, I have Ms. Bacchus.
Misty Bacchus, CR 21158. So she's set for arraignment today?
Yes, Judge, we've gone over the indictment. Her name is spelled correctly. She understands the charge against her. She's pleading not guilty to this.
All right, court will enter the defendant's plea of not guilty into the record and will set for pre-trial. Are you available on September 14th?
I'm sorry.
September 14th?
Yes, Judge.
September 14th for pre-trial at 9 a.m. Once you receive your yellow copy, you're free to go. Is that all you have, Mr. Manning?
Yes, sir.
Mr. White, are you ready?
I am.
Anyone you want me to call first? Mr. Wright, CR 21148.
Your Honor, I believe we set this up and call it a day. I spoke with Mr. Black. We're still trying to work through this case. He requested that I provide him something. I'll give you that on 30 days. I'm optimistic that we should.
Any objection from the state?
No.
All right, court will reset for docket call on September 14th at 9 a.m. And so, state, I want to disclose at this time, Mr. White, I'm sure is already familiar. Mr. Wright and I, small town, we went to high school together, kind of grew up together. We were friends in school, as I was with Mr. White. So I want to go ahead and disclose that to you at this time. I do have a personal knowledge of Mr. Wright and his brother, his family. And so I want you to be aware of that.
This judgment, truthfully, Mr. White has previously made me aware of that as well. I believe our discussion revolved around if we reach some point where we believe it will have to be contested, we may make some motion at that time. I believe we can get this resolved without a contested matters necessary, and state at that point have no objection to your Honor hearing that. If we do reach some point where we believe it's contested, we need to make some decisions. We may or may not have that.
Okay. You're free to go. You want next? Sure. Mr. Hamilton. This is CR 2171, State versus Roy Hamilton, set for pretrial.
Your Honor, we just got to be on that. We said it will be space in the actually. Any motions that when you file.
All right.
The state's understanding.
All right, court will reset pretrial to September 14th at 9 a.m. Mr. Hamilton, once you sign the notice of setting and get your copy, I need you to come over here to pretrial release and check in with them. We have some additional paperwork for you. Mr. Zarate? All right, Mr. Zarate, if you'll raise your right hand, sir, I'm going to place you under oath. This is cause number CR 2278. Mr. Zarate, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may put your hand down. Mr. Zarate, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White's representation of you? You feel like you've had enough time to discuss your case with him, have all your questions answered? Anything about this paperwork that I have that you've signed that you do not understand? Mr. White, do you believe Mr. Zarate to be competent today?
Your Honor, I believe Mr. Zarate speaking to the speaking piece of the court are I believe these ways of rational, intelligent, voluntary. I don't know the fact that this case is what goes wrong with the agreement. Advantages, entering such agreement, most of it violates the term and condition. I mean, we'll hold the hearing to determine whether or not he violated it, safely that by hundreds of evidence. So I think that 1 year in the county jail, of course, if he completes the agreement, the case will be dismissed and shown in record as an arrest.
Thank you, Mr. White. Mr. Zarate, do you understand that full range of punishment that Mr. White just stated on the record? Have any questions about that?
No.
You also heard him state the plea agreement in this case. Do you have any questions about it?
No.
Understanding that you are pleading guilty to a Class A misdemeanor, lesser included offense of assault causes bodily injury, how do you plead? Are you pleading guilty to that Class A misdemeanor offense because you are guilty of committing that Class A misdemeanor offense of assault causes bodily injury?
Yes, sir.
All right. Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right. Court accepts the defendant's plea of guilt. Any objection to states one?
No,
States one is admitted. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, I will note that we have sent a victim impact statement to the alleged victim. We've been in contact with him. He has not returned the impact statement to our office. He's also indicated that he doesn't really, he wants the two gentlemen involved to pay some penalty, but mostly he is interested in restitution for his medical bills. Beyond that, he has no real interest in any of these cases. I will note for the record that Mr. Zarate is co-defendant. His case was previously dismissed because he was deported. We have just recently re-indicted him. Return. There is a substantial amount of restitution that Mr. Zarate is responsible for. We expect that he co-defendant will be responsible for a substantial amount as well, if and when.
But as it stands, there's no joint several in the plea agreement.
No.
Okay. And so, Mr. Zarate, you understand that you're being ordered to pay nearly $6,000 in restitution, and that's going to have to be paid in less than 2 years.
Yes, sir.
You understand that?
Yes, sir.
And you understand that's a condition of your community supervision?
Yes.
Your community supervision that you're going on, you understand that's a condition of it, that if you don't pay, that you could be revoked, adjudicated, and sentenced up to 1 year in the county jail.
Yes, sir.
You do understand that?
Yes, sir.
Judge, not to interrupt, but if he is sentenced, he would still owe that. It's not one of those we sit out. Just make sure that Mr. Zarate
be so aware.
Okay. Anything further from the defense?
No.
right, the court has reviewed the evidence and the court will follow the recommendation of the state and the plea agreement. Court hereby finds sufficient evidence to convict Mr. Zarate of assault causes bodily injury. Court will defer a finding of guilt. Will place Mr. Zarate on deferred community supervision for 2 years. Order him to pay restitution of $5,808.38 and court costs of $270 in addition to an $85 reimbursement fee. Mr. Zarate, how old are you? How old are you? 22. What do you do for a living? Work in metal buildings,
Yes.
like constructing them and building them?
Yeah.
Have any kids? Have any kids? Children? Married? Girlfriend? Family?
Yeah.
Do you plan on having a family one of these days? You hope to you hope to make a lot more money in your job? You understand that having a criminal record's going to interfere with that?
Yes, sir.
You understand that having a felony offense on your record really inhibits that? I mean, to the point to where you might not be able to get a good paying job at all, which could interfere with you being able to provide for a wife, children, family. You understand that? 22 years old is really young to be already on probation and having to pay $6,000. You take it serious, all right? Because I do, I take it serious. All right, Mr. Zarate, I want you to come forward to be fingerprinted with the deputy. After that, I want you to report over here to the officers with the probation department. Good morning, Mr. Abrams. Can you see and hear me okay? I'm gonna ask you to unmute there. There we go.
Yes, sir. Can you hear me okay, Judge?
Yes, I can hear you now. I've got your client. I pulled Mr. Lopez in, however, he's got no audio, no video.
Oh, he's on though. Is he on?
Well, he's logged in, but I can't see him or hear him. So I just see his name. And
Yeah.
that means
he
he
may be-
can't see or hear me either. He may be able to see me, but he can't hear me.
He may be having a problem with that, Judge. Can I?
Here, we've got him now. We have him now.
Okay, great. Thank you.
Mr. Lopez, I'm going to prompt you to unmute. When I send you this button, I want you to push it.
Okay.
All right. Can you hear me?
Yes, sir.
Okay. Can you see your attorney, Mr. Abrams?
Yes.
Okay, excellent. All right. This is cause number CR 21-177, State versus Raul Lopez, set for pretrial. Mr. Abrams, do you have any contested pretrial motions on file?
No, Your Honor. I just want to let the court know we are going to be entering I spoke to Tyler. He's actually just sent me the paperwork. We're going to be entering into a pretrial diversion agreement with the court's permission. We were just waiting on. They sent us a video, and the video apparently didn't have anything on it. So we contacted the DA's office. They're checking into that. But when I spoke to your coordinator, she indicated, if it's okay with the court, August 26th would work for the court's calendar. If we could do that, we can do the pretrial diversion agreement on that day if that's acceptable to the court.
Okay. Does Mr. Lopez have any COVID issues at this time?
No, I don't. And I will be there also, Judge.
Okay, good.
No, I'm going to
Okay.
be there. I'm not going to, I'm not doing on Zoom. I definitely want to do that in person.
The 26th is an evidentiary day. I have the 24th. The 26th I reserve for evidentiary matters, contested hearings.
That's fine, Judge. Let me take a look and just, I want to make this happen for sure. Okay, let's do it. Let's do it on the 24th. Let's do it on the 24th. Mr. Lopez, are you okay with that date?
Yes.
Okay, that would be fine, Judge.
Okay, and if the 24th is crowded, I mean, we can look at September 14th or 16th as well.
No, as far as I'm concerned, the quicker he gets into this, the quicker he'll be done with it. So
Okay,
I don't mind being there like really early, Judge. I'm an early riser. I can be there at 8, 8:39, whenever the court tells us.
you'd be by yourself until 9, so.
Okay.
All right, Mr. Lopez, we're going to set you then to enter your plea with the court on August 24th, and it'll be at 9 a.m. But if you'll get here at 9 a.m. and be ready to go with your paperwork, we'll get you in and out.
Judge, just for my sake, should I get the paperwork in, the diversion paperwork in before that date, or it doesn't really matter?
As long as you have it with you in court that day, the quicker you go over it with your client, have your client sign it. If you show up with it ready, already executed and ready to go, witnessed and everything, then that's the only thing that slows us down.
That's fine, Judge. And just from my knowledge, Judge, because I do work in mostly the Dallas County area. Let me get this off. I'm assuming, Judge, I'm assuming that we entered the plea, but if he successfully completes it, then it just sort of goes away with the diversion.
Yes, it doesn't sort of go away. So if the defendant successfully completes all the conditions of the pretrial diversion or pretrial intervention program,
Yes, sir.
the state will tender to the court a motion to dismiss, and then the court will dismiss it altogether.
That'll be great. Okay, but we still enter a plea on that day, or?
Yes, you'll appear, and I'll put him through I'll swear him in, and I'll put him through some question and answer about some of the rights that he's waiving, such as waiving the right to a speedy trial, waiving the right to limited expunction of records, because the program does not allow you to expunge the DA's office or the probation
Yes, sir.
records. We'll go over those things, make sure he understands what he's waiving, admissibility of evidence, go over those things. Court will most likely approve it, sign it. He'll go into the program. He successfully completes it. State tenders a motion to dismiss at the completion.
Yes, sir. That'll be great. Okay, Judge. Well, that sounds fine to me then. So August 24th, 9 a.m. That'll work for us, and I'll be there in person.
All right, Mr. Lopez, you understand August 24th, 9 a.m.?
Yes, sir.
All right, thank you, gentlemen. Free to go.
Thank you, Judge. You have a nice
Thank
week.
you.
Okay,
as well.
bye-bye. Bye.
What do I do here? Leave?
All right, we're back on the record, CR 2264, State versus Douglas Mercer. Officer Waddell, court previously placed you under oath. You're still under oath for purposes of your testimony. I asked you to conduct another urinalysis of Mr. Mercer so we could try to get to the bottom of some of these issues of whether or not he has any prescription medication that's causing any type of controlled substance or narcotic to be present in his sample. Did you test him?
I tested him this morning. Results of that test was positive for methamphetamine, positive for either substance.
All right, any questions for Officer Waddell?
No.
Thank you, sir. Mr. Mercer, I don't know what to do with you, sir. You don't know, you don't know either? All right, well then that'll make my mind up for me. Mr. Mercer, I'm going to find your bond to be insufficient and order you into custody at this time for violation of conditions of pretrial release for testing positive for marijuana.
And Judge, I think that,
Did we take him off?
well, I think it's an issue.
Well, he failed to appear at the last setting. And so we were holding the warrant, the NISI, in abeyance until today to see how the next date will be the 30th. Oh, you're gonna be on the panel? It's probably one of the best. It's one of the best motion for continuous grounds right there.
Every question, every question.
I'm selling a drink. I mean, journalists. Sure, we're gonna fix it, right?
Good. It's a good thing. Let's do the pretrial release order. Not worry about the missing jury selection. He tested positive for methamphetamine and marijuana. Yeah, actually, I just said for testing positive for marijuana. So, because he's claiming he's got a prescription. So just put tested positive for marijuana. Thank you.
This is
All right, we have anyone that's ready? Who are you ready on, Mr. Ashmore?
Ready on. I'll hold my time, Mr. Dobbins, and Mr. Nichols, and go in order to the chair.
All right, Mr. Dobbins. Is Mr. Dobbins a plea today?
No, Judge, the word says for.
This is CR 2158 State versus Randy Lee Dobbins. Go ahead, sorry.
Sorry, Judge, I'm so sorry. We do have an offer for $3,500 fine, court costs, and conditions of probation. We discussed all the details about that, including what a deferred means, so brief punishment for missteps. And of course, the sanctions for missteps, not an automatic revocation, what a revocation is. But my client would like to ask for the privilege of having a reset. I think this is just an arraignment. If we just come back on a free trial, I think we'll be ready for decision day.
All right, has he been presented with the indictment?
Out of abundance of caution, I don't know, Judge. Cannot remember. I thought we had done that stuff already. The answer is yes. We looked at it earlier and talked about it beforehand. Judge, this indictment, and one of the reasons why the state of Texas, gracious, my Mr. Dobbins, has two enhancement paragraphs, which we have agreed with the state are going to be amended because they refer to his brother, who has committed crimes using his identity in the past. We run this Mr. Dobbins, who looks identical to his other twin brother, Mr. Great. That being said, the first paragraph, my client has identified his and
Well, let's just do it this way. Is his name spelled correctly in the primary offense?
it is.
Does he understand what he's being charged with?
He does.
Does he enter plea of not guilty?
He does.
And as to the other two enhancements, does he enter pleas of not true to each one of those?
He does.
All right, court enters Mr. Dobbins' plea of not guilty and not true into the record, and the court will set this for a pretrial hearing. Are you available on September 14th? Well, I'm asking Mr. Ashmore if he's available. He's checking his schedule. It's either the 14th or the 16th.
We're ready soon, maybe come back soon.
No, I'm pretty full. I'm already at capacity. Thursday, I mean, you can come back Thursday, but I don't know if you'll be ready by then. All right, Mr. Dobbins, so I'm setting you for a pretrial hearing on September 14th. If you enter your plea that day, that's great. If not, then we'll talk about pretrial motions and another hearing. All right, so once you sign and get your yellow copy, you're free to go. All right, Mr. Nichols, if you'll step around. All right, this is cause number CR 2187, State versus Jason Eric Nichols, set for docket call.
Well, Your Honor, we have an offer of 10 deferred, 5 years TDC deferred, 10, $2,500 fine, court costs, $1245 to charge downstairs. My client has tested positive for drugs today, and we anticipate the court is going to find that this violation of pretrial release conditions, and he's going to force him in Zane County Jail. We're asking for an additional docket call if we can ask for with privilege in that because I've been presented with some information by Mr. Nichols and his mother today that we would like to present to the state to further lock down our negotiations.
Can I get a clarification on the offer?
Yes, Your Honor. The current offer is for 10 years CDC credit, straight probation, not. We're still talking, but that's the same current offer.
I'm sorry.
All right, the court will set Mr. Nichols for any objection to a request for an additional docket call. All right, court will set Mr. Nichols for a docket call on September 14th at 9 a.m. The court is going to find that Mr. Nichols is in violation of his conditions of pretrial release. Court finds his bail to be insufficient. Mr. Nichols, you're ordered into custody and the court has set new bail in your case. Yes, sir. Do you have any more on the docket this morning?
Not this morning. Patience. Get my flight.
Mr. Adams, are you ready? Rochelle Cofer. Is this a plea today? Do we have the paperwork? Oh, here it is. All right, this is cause number CR 20285 and 320. Scofer, if you'll raise your right hand, I'm going to place you under oath. Scofer, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got.
Yes, Your Honor.
All right, you may put your hand down. Your name is Rochelle Lynette Cofer, is that correct?
Yes.
Ms. Cofer, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes, Your Honor.
And have you ever been diagnosed with any type of mental condition?
Yes, Your Honor.
And what is that?
Depression, psychosis.
Are you currently undergoing any type of treatment or on medication for any mental health?
Yes, Your Honor.
And do you feel like those medications and treatments helping you today to where you can have a rational understanding of the proceeding?
Yes, Your Honor.
And Mr. Adams, do you believe your client to be competent today?
I do, Your Honor. Respect for about these two cases. And in every instance, she's having depression. She understands what we're talking about. She has a rational frame of mind, despite her diagnosis. I understand she's medicated for uneducated perspective.
And you've explained the plea agreement to Ms. Cofer and her legal and constitutional rights.
That's correct.
Ms. Cofer, are you pleased with Mr. Adams' representation of you? Feel like you've had enough time to discuss your cases with him, have all your questions answered?
Yes, Your Honor.
Anything about the plea agreements that you've read through and signed that you do not understand?
No, Your Honor.
All right, Ms. Cofer, in cause number CR 20285, you are charged by indictment with interference with radio frequency or interference with response. That is a state jail felony offense. And in CR 20320, you're charged with a Class B misdemeanor offense of driving while intoxicated. In the felony offense, I see that the plea agreement is that you're going to plead guilty to that charge in exchange for the state's recommendation that you be prosecuted under Section 1244A of the Texas Penal Code, which means that if the court were to follow the plea agreement, you would be prosecuted as a felon, convicted as a felon offender, but you'd be prosecuted punishment under that of a misdemeanor, which carries a range of punishment of not more than 365 days and not more than a $4,000 fine. So do you understand that range of punishment on the interference charge?
Yes, Your Honor.
And I would find that the proposed plea agreement does legally fit within that range of punishment. On the driving while intoxicated, the Class B misdemeanor, the sentence couldn't be more than 180 days, and it cannot exceed a fine of $2,000. And I see that the plea agreement in that case is that you would plead guilty in exchange for a 180-day maximum sentence with credit for time served previously. And you'd be ordered to pay a $1,000 fine in addition to court costs. And in that case, the state is also dismissing a driving while license invalid case. Is that your understanding of the plea agreement in that case?
Yes.
Right, understanding the range of punishment and the plea agreements, let me ask you, how do you plead to interference with radio frequency or interference with response? And to driving while intoxicated, Class B misdemeanor, how do you plead? Are you pleading to each one of those charges because you are guilty of committing each of those charges?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty to either? All right, the court will accept the defendant's plea of guilt. Mr. Adams, any objection to states one in each case?
No objection about it.
States one is admitted in each case respectively. The court does take judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor, we would rest the closing.
from the defense?
We rest the closing.
All right, based on the court's review of the evidence, I find sufficient evidence to convict Ms. Cofer of these offenses. The court will follow the plea agreement in each case. Court convicts her of interference with radio frequency or interference with response. Court, under section 1244A, the court assesses her punishment at 235 days in the county jail. We'll give her credit for time served. Court will order her to pay a fine of $1,000, $690 reimbursement fees, and $290 court costs. As to driving while intoxicated, the court convicts her of that offense, assesses her punishment in accordance with the plea agreement at 180 days confinement in the county jail, or issues credit for time served, orders her to pay a $1,000 fine in that case, in addition to $270 court costs. And the court dismisses under section 1245, driving while license invalid, DA 2026A2. Mr. Adams, is your client paying any of her fines that she owes today?
Thankfully, we started our, in fact, I was plan.
Have you admonished your client on what happens if she doesn't pay the things that she's ordered to pay?
I'll do so.
Thank you, Mr. Adams. Ms. Cofer, you hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with the deputy. And then she's gonna hand you a card that has the contact information for the court compliance officer. You need to make contact with her as soon as possible. She's not here today, as Mr. Adams said, so that you can make arrangements to make payments. And as long as you're making a good faith effort to discharge what you owe, then the court will not issue a warrant for your arrest. You understand?
Yes, sir.
Okay. I'm gonna go ahead and have you step forward to be fingerprinted here with my stand-in bailiff. Ms. Cover, just come right up here with Officer Mature.
No, that's all I have on the docket, six after this.
Yes, sir, you may. CR 2263, State versus David Wayne McLaren. Mr. McLaren is set for a docket call today.
Good morning, Your Honor.
Good morning, sir.
First of all, apologies. We have discussed, there's an offer on the table. We have discussed the case with the prosecutor. There's some things he wanted to look at that may or may not generate an offer. If the court will allow us to place it on one more docket call, I think that will resolve. That's the state's understanding. The court, subject. And he's reviewed that and we got some spelled correct. So,
All right, are you available on September 14th or 16th?
14 is great.
Okay, we'll set Mr. McLaren for a docket call on September 14th.
He was supposed to be paying for the pretrial services. He's behind and realized his wife hasn't called in a credit card. But we're waiting. He's going to go check with the
Well, and I showed that the biggest portion of the delinquency is for attorney fees. Well, you're retained.
That's correct.
So if he has credit, I only show that he's $15 behind on bond supervision. So
Okay.
we'll need to, what I would recommend is speaking with pretrial release here and let them know, because they're probably not aware that Mr. Pappas is retained. Therefore, they won't collect that additional attorney fee from you. So if you've got that paid in, then that'll cover your bond supervision for quite some time. And
I
then,
just want to know.
yeah, well, and I saw the delinquency, but I saw that 200 of it was attorney fee. And then I saw you standing there and I knew that he's not delinquent in that. So yeah, once you sign, then check with them, let them know that Mr. Pappas is retained and they might be able to give you a credit towards the rest of it, toward your future bond supervision. Okay. So once you sign and get your yellow copy, do you have the notice of setting? Did you fill out the notice of setting?
I gave it to the court. I gave it to Dana, but I think she did it before.
And he's already signed it?
Yes.
Yeah, usually y'all keep these and then we put the dates in there and then you give it to your client.
Okay.
That's your client, then he's free to go, but I would check in with pretrial before you go.
You will. Thank you very much.
You're welcome. You're welcome. Yes, ma'am.
Brittany Sherwood on this afternoon.
I understand. Yeah, she's in Henderson County. Why don't you just pick a new date? We'll reset the arraignment.
Okay, we're working, they've just given me the evidence. I haven't been able to review all the discovery, but I think we'll probably get it worked out pretty quickly, provided we get through the COVID
Yeah.
period.
Do you know your calendar, like either September 14th or 16th?
I think the 16th, Judge.
16th be better? All right, let's do that. I'll just reset arraignment to September 16th. And Ms. Taberham came and told me that she was being housed over there with them being in quarantine. We didn't have time to set it up, so. And then she said you're adding a few for plea today?
Yes, sir.
Okay.
We've got a plea on Mr. Williams, Michael Williams. I just got one of them yesterday. We got that one worked out. And we do have a plea on Ms. Heflin, who's already on the docket for this afternoon. So I'm just waiting on the paperwork.
So Williams is the only one we're adding?
Yes, sir.
Do you have his cause number by chance? If not,
I'll probably do that. I believe it's 021 -00200.
21,200? Okay. And what's that charge?
Drug case, manufacturing,
Second degree?
second degree. Curry's agreed to do an oral amendment. We'll bring it up during the plea. The body of the work is just 4,200. It's
It should, but it's okay. I see. It's third degree enhanced by the manufacturer of the possession with intent. Okay. Okay.
Reset on Tessaberry County,
Okay.
so we'll just reset those.
Let's go ahead and put that date in there. Is he coming back on any other cases? If not, then yeah, he's here on Ronald Brown. So I'll just have him announce. And we'll. All right, so Blevins, we told 3:30 at the jail.
Yes, sir. To see if she could hear.
I haven't taken that one under advisement. The one that I took under advisement was Mr. Schmidt's client, who is Derek Piscata in Nebraska. I've got that under advisement till noon on Thursday. So what I remember Mr. Gimbel saying was he was gonna go back to his office, call the Genesis Center. He said he would let Patty know what kind of arrangements she could have as far as checking in via Zoom. So I'm kind of waiting. I'm gonna have her name called. So if I don't hear back from Mr. Gimbel today, do you have any information on her?
Judge, she emailed myself, Mr. Gamble on Sunday, basically said that Genesis had called her, told her that they had bed for her, and
All right. Court has concluded the morning docket. Those who did not appear, their names have been called loudly and distinctly 3 times in the courthouse. Court will be issuing judgment not size or taking them under advisement. We will adjourn.